Very good evening to all of you. So we continue our live interactive sessions aimed at helping you to make progress with your preparation towards 2021 Ghana School of Law entrance examination. Last week, when we met, we shared thoughts which have been gathered from experiences examiners that have been part with the process. Yeah, so we've done that. I'll call you back. I'm online. I'll call you back. Yeah, so we've gathered the experiences part of the process. So what we intend to do tonight is to come back to Ghana legal system, and the purpose is not to do any comprehensive discourse, but do some sort of like a mopping up revision, but based upon maybe issues come up. If I get a sense that some of you will need some kind of a thorough, comprehensive discussion of some particular matters, we'll do that. So one thing we have to notice that we have to take an legal system important because it is an area which will be examined most likely in two aspects of the exams. The MCQ, of course, and if you look at last semester, there wasn't any direct question on the Ghana legal system, but well, who can tell whether this particular year there will be one. And for that matter, before we move on, for Ghana legal system, if you don't revise anything at all in detail, basic areas like sources of law, right? You need to know your sources of law very. And if I say sources of law, simply Article 11, as explained in detail, with illustrations and all that. You have to know that. And then apart from sources of law, you also have to revise in detail of course, source of law, the doctrine of a judicial precedent or stare decisis. You have to know it very well. And certainly the court structure. You have to know like the court structure. I think there have been a few amendments to the court structure in terms of the organization of some of the lower courts, especially the district court and then the circuit court. So those who are not familiar, you can put the material on the platform, or I'll put the material for you so that you know in terms of the monetary position, there has been some increments. And of course, apart from the cost structure, we also need to revise the basic principles of statutory interpretation. And of course, as well as overview of criminal procedure, summary, trial and indictment, and the arrest and so on. And then we should also know an overview of a civil procedure and ADR. So if we are going to revise anything at all, I think it's important that you pay attention to some of these areas, because if you look at the most examinable areas, I mean, these are the main areas. Of course, other things like legal aid commission is also there. It will not be a bad idea to also look at that. Yeah, I think if you look at these matters, you should have made a reasonably good preparation as far as the Ghana legal system aspect of your examination is concerned, I think. Yeah, so in terms of the MCQ and the possibility of Ghana legal system question coming, we can definitely not rule that out. But nobody knows how many questions will come. Sometimes you look at the kind of questions, and maybe just about 3 or 4 questions coming from the Ghana legal system and legal method. Yeah, so since we don't know which ones, I think that it is very useful and very helpful for us to keep reminding ourselves about the basic. And those of you who didn't join us the last time, I should like to remind you that I come to these lessons, active session with you in the sure knowledge that you are not learning these matters for the first time. It's something that you've learned already. And that is why you have your Bachelor of Laws degrees, or BA Law as it were. So that is the starting point. Of course, we also appreciate the fact that because some of you finished, even those who finished not too long ago, Ghana legal system, you will learn it usually the first year. So the tendency is that some of you have forgotten some of the things, and that is why it is sensible for us to go through and read. And if nothing at all, just take a legal system book. You take a EK Kwanzaa book, and then you take my book. You can just run your eyes through most of the topical areas, and in addition to whatever news that you had when you were a student in the various law faculties, I think you should be good to go. Now, before I move on, let me say I have become cognizant of the fact that a good number of the law faculties have completed examination for the final years. What it means is that you are more available for more learning towards your entrance examination. So I propose to probably add 1 or 2 more sessions to what do. When it's a workout, I will communicate it to you so that if you're able to come, as and when we're having it, you can join us. If you are not able to come, because we have developed the practice of maybe trying to record and upload on the YouTube, as and when you have the time, you can just play it back and listen as you're doing whatever you are doing. And so these are just a basic housekeeping rules I think that I should bring to your attention. But so what I'm going to do, as I said tonight, is just to run through as many areas, just talking around, and there'll be a session that maybe I'll show some questions for us to discuss. And also, let's do it this way, probably as people have specific questions, we can also discuss that, and we learn together so that we deepen our understanding of areas. Who knows? As I said, fundamentally, no one should have any certainty regarding which areas are going to come. But what is important is that since these are basic matters, we're supposed to have reasonable mastery of them. Yeah, so let us apply ourselves in that respect. So having said that, as part of my general, if you like, a broad brush approach towards revision in Ghana legal system and legal method, I will start by saying that in case you have forgotten, we distinguish legal system from legal tradition. So when we say legal tradition is a bigger one, and then the legal system, if you like, is a subset or in a particular legal tradition. So legal tradition basically refers to how society has developed ideas and beliefs and practices regarding the making of law application of law in society. And these ideas are as scholars or authors like the Merriman, for example, say they are historically deeply seated, meaning that they have developed over a long period of time. And for that matter, society has come to have a certain understanding of, if you say law, like what counts as law, how law is made, how law is applied, and institutions related to the making and application of law. How society has come to actually understood, how society has come to rationalize, think about this, philosophize about this. That is what we call legal tradition. And legal system is specific to a particular jurisdiction or a particular country, as we know. So it's simply the collection or the assemblage or putting together the laws and then the institutions for making an application and enforcement of the law. That's what to give you like the legal system. Yeah, so you notice that that is why some scholars will say that it is a family of legal system, like a legal tradition. So fundamentally, we have like the major legal traditions. We have the civil law tradition, also known as the Roman Dutch law or the continental legal tradition, which derives its source mainly from the Roman law, where we have a lot of civil code or codification, meaning that almost everything about the law is systematically organized in a particular enactment called the codes. And judges have very little role in shaping the law, in the sense that almost everything is worked out for them in the code. And all that they have to do is to look at the code and to be applying it to scenarios. So they just don't really make precedent, as we know. So stare decisis is not an important part in the civil law tradition. An example of civil law tradition, if you come to, let's say, Africa, we can say that all the French-speaking countries belong to the civil law tradition, because the Napoleon Bonaparte, his conquest and all that also furthered the spread of the civil law tradition in some parts of Europe, and then subsequently the colonies that were colonized by some of these European countries. Then we also have our own very familiar common law tradition that we know. The tradition which developed with the development of the modern day England following the Norman conquest in 1066 AD. That is the 11th century. And then it's marked mainly by the fact that the law is scattered through judicial decisions, or what you call a judge-made law. And judges have more role to play in shaping the law rather than their counterparts in the civil law tradition. And of course, as I said, the stare decisis or judicial precedent is very important there. And that tradition, as we know, is associated with the Great Britain and all the colonies that they were able to colonize, more or less also had a legal system which is founded upon the legal tradition. And Ghana, of course, is no exception. So our legal system belongs to the common law tradition and not the civil law tradition. Of course, mention may also be made of like what we call like the socialist tradition. It's not really important now. It used to be very important when we had like the Cold War, the USSR, the Soviet Union. Well, some would say that Russia, to some extent, and maybe China practice some aspect of the so-called socialist tradition, but it's not really a big deal for us in examination really like this. So I thought I should just quickly bring you to speak on that. And then again, having revised the basic civil, the law tradition versus legal system, we also like to quickly come back to classification or division of law. We often talk about law as being be in need of classification or needs to be divided up for purposes of convenience and application. And there are so many ways in which this may be done. So first of all, we can talk about municipal law as against international law. Municipal law is known as the national law or the domestic law, and it refers to the law which is applicable within a particular jurisdiction. So a Ghanaian law is a municipal law. Then international law, as we know, the law which governs relationship between various nations or various states and so on. Yeah, so let's be aware of that, and I think that is fine. So for example, if in your justice, MCQ, you've seen ECOWAS Treaty, you've seen the African Charter, you've seen all these things, you ask, which type of law does this thing belong to? You have to know that we're talking about international law. We're not talking about municipal law as well. And then related to that, let me also remind you that Ghana is a dualist country. If you look at Article 75 of the 1992 Constitution, what it means is that once the executive has actually signed up to a treaty, it does not have immediate binding effects in Ghana unless it has been domesticated by means of incorporation. And incorporation is done in a number of ways. Either Parliament will pass a particular legislation saying that this treaty or this convention, which the executive signed, has now been ratified in Ghana, and then a legislation may be adopted, or Parliament may simply just pass a resolution for that to occur. So look at Article 75, but what that matters for our present consumption is that just remind ourselves that Ghana is a dualist country, and for that matter, treaties signed need to be acted upon before it can have binding effect in Ghana. And Article 75 gives us that kind of direction. So let's keep that in mind. So apart from classifying law as municipal or international, well, we may also classify it as a public law as against private law. Public law as against private law. So by public law, we are referring to all those aspects of national law, which first of all, either set up the states and the various organs of the states, and then defines a relationship between the states and the citizenry. As examples of public law: constitutional law, criminal law, administrative law, environmental law. All these are public law examples. And the private law, of course, we have our usual civil law. Or, of course, most of the, not all civil law, most of the civil law are private law. So we talk about contracts, we talk about torts, we talk about equity and trusts, land law, and all these are examples of private law in the sense that they mainly govern relationship between citizens. Of course, it's also possible for it to also govern relationship between the states and the citizen. You know from the Constitution that it's possible for the state to enter into contract and things like that. And the state can sue for contractual liability and also for tortious liability. Look at Article 293 of the Constitution. It will give you a clear confirmation that the state can also be involved in private. So when we say private law, it doesn't mean that it's only for the citizenry. It's just for the historical aspect of the development. That is why it's explained the way that it is. And then again, another important classification, which is often done, is that you're invited to distinguish between criminal law on one hand and then civil law on the other hand. I mean, in terms of maybe examination, maybe examiners of Ghana legal system and method, maybe that is one popular area where you're invited to distinguish between maybe either crime and civil wrong, or they will say that the criminal law and civil law, as it were. So first, we know criminal law, aspects of the public law, which deals with the offenses. And if you say like offenses or a crime, you have to know right away that in Ghana, with respect to Article 9 of the Constitution, we are told that nothing is a crime unless it has been defined in a written law and then with the prescribed punishment. Yeah, so that is how we get a crime. And the whole branch of the law which governs that is what you call like the criminal law. Yeah, and of course, we also have our civil law. Civil law, that aspect of the law which addresses like the civil wrongs. So there are various aspects of it: contract, movable property, having insurance, employment, labor, landlord, torts, and all these are examples of like the civil law. Maybe let us focus it. If you are asked to distinguish between a civil wrong and a criminal wrong, you are asked to distinguish between like the civil wrong and the criminal wrong. Somebody said Article 200 is the police service. I think I haven't talked about the police service tonight, unless maybe somebody has put something there. You have something related to that, then you can come clear, but I haven't mentioned police service this evening. All right, thank you. Yeah, so I was saying that in terms of crime, you may be invited to distinguish between maybe like the crime and a civil wrong. I think we'll look at that just in a minute. We'll look at that in a minute. But as I said, I am not going in a very strict script manner. In other words, I'm not following like a detailed script. I'll just be speaking around the area that we're talking about. And then we look at some questions, and then as and when you raise questions, then we will deal with them. Yeah, that is a way we can cover a lot of grounds. Otherwise, if you are to do like the typical school term approach when you were learning it as an undergraduate student, we will not finish even 4 or 5 topics in any subject before you go and write your exam. So let us proceed in that manner. So as and when, like let's say now the topic we are doing, the area we are doing, as and when issues come up, and so we will engage them. But we'll come and say a few more words about the distinction between crime and civil wrong. Because I said that that is one interesting area. Even if it's not going to come in a direct form, we'll get a scenario type of question in which your knowledge of the distinction may be tested in one way or the other, as it were. Okay, then we also talk about substantive as against procedural law. Procedural law is also known as adjectival law. So substantive law simply addresses the law which spells out rights and duties of individuals as it were. Yeah, but in terms of adjectival law or procedural law, it enables us to know how substantive law is to be applied to particular cases. Let me give you a typical example. Torts, contract, criminal law, constitutional law, in a sense, all these are substantive law in the sense that they will tell us what our rights and obligations or duties are. However, how to really actualize, how to operationalize these aspects of the law, we need another set of law. And that set of law which enable us to know how these areas of the law are applied as what we call the procedural or the adjectival law. So for example, you have like the Cause Act. The Cause Act is an example of, to large extent, an example of the adjectival law because it tells us how we can assess the court or which court can do what what you can do here and what you cannot do there, as well as the rules of court, the district court rules, high court and the civil and the circuit court rules. All these are administrative law, procedural law, because they tell us how we can assess various judicial fora for purposes of vindicating or getting redress for our rights that might have been violated or breached by other people. So let us remind ourselves, just in case we have forgotten some of matters. So maybe let's quickly look at the distinction between the civil and the criminal law. And within that, as I said, either you have to distinguish between that civil and criminal law, or you have to distinguish between civil and the crime, as it were. If whichever way that it comes, essentially, we're talking about the same thing. So we know in terms of the criminal law, as we have said, is between the states and the individual. And the purpose of criminal law is to require citizens to behave in a certain way or a certain manner. And if they are not behaving in that way in terms of doing what is expected of them, or avoiding what is not expected of them, or not doing certain things they're not supposed to do. And this is actually secured by punishment or sanction. So that is the purpose. The purpose is to punish a citizen that will not follow the prescribed behavior by the state. But if you look at civil law, and for that matter, civil proceedings, the purpose is to assist the individual to enforce his right against another individual, against the state. Maybe either you are to recover your property or enforce obligation, as it were. And the main aim of civil law is to usually help the individual to get compensation for his loss. That is like the common objective, to help the individual get compensation for his loss. A loss either arising from a tort, a loss arising from breach of contract, or some other form of contract type of transaction, as it were. So yes, we are not saying that there cannot be compensation in criminal cases, but that is not the main objective. So if you look at the if you look at the Cause Act, for example, if you look at the Cause Act encourages reconciliation, and that may probably also require some payment of money for certain lesser offenses. But that is not the main objective. So that is just, if you like, the tangential, or just a periphery aspect of criminal law, as it was. So let's keep that in mind. And then in terms of procedure, yes, in terms of procedure too, we have a clear distinction. We know that yes, it is possible for the same court to have both, to have jurisdiction or power deal with civil as well as the criminal proceedings. There's no doubt about that. But there are certain situations too in which certain type of criminal proceedings may be done in particular court and not as it were. So let us keep that in mind. And who initiates it? We know that criminal proceedings are initiated by the Attorney General in the name of the Republic. In the name of the Republic. The Attorney General who initiates, but we don't say that Attorney General versus the accused person. No, the Republic versus the accused person. So pay attention to the title. It's very important. And under the 1992 Constitution, we don't say the state. We don't say the state versus the accused person. No, the Republic versus the named accused person. So pay attention to that for purposes of your multiple choice questions, as it were. And Usually, when the Attorney General initiates criminal cases, we say that they've embarked upon prosecution. As we know, this may result in conviction or acquittal. If you are convicted, means that you have been pronounced guilty beyond reasonable doubt. And of course, what follows is that you are going to be sentenced to the appropriate punishment prescribed under the law. On the other hand, you may be acquitted, meaning that you have been proven innocent of the particular crime, because the prosecution failed to prove your guilt beyond reasonable doubt, and then you are consequently declared innocent, and you are acquitted. Yeah, so again, in terms of procedure too, we have to pay attention to the burden of proof and then the standard of proof. Yes, in criminal case, the standard of proof is proving the guilt of the accused beyond reasonable doubt. That is to say that the prosecution, the Republic, or the Attorney General and his various agencies that are representing the Republic will have to bring requisite evidence to demonstrate that, yes, there's no doubt concerning, there's no reasonable doubt concerning the guilt of the accused person. If a reasonable doubt is raised concerning the guilt of the accused person will not be found guilty, and he will be acquitted, as it were. So the standard of proof is proof beyond reasonable doubt. But if you look at the civil cases, you notice that the standard of proof is different. It is preponderance or probability. Preponderance or probability. In the old literature, of course, if you still look at the English literature, they say balance of probability, but under our Evidence Act, we use the language preponderance of probability. So that is the standard of proof in civil cases, as it were. Then we also note that in terms of burden of proof, in criminal cases, is the accused person, the prosecution that has a burden of proof, that has a responsibility to prove the case against the accused person, as we know. And that is why the accused person may sometimes even make what they call the submission of no case. That is to say that after the prosecution say has finished proving his guilt, the accused person may say that, well, due to XYZ, the prosecution has not made any case of guilt against me. So he will make a submission as it were, and so on. Yeah, so in terms of civil action, the initiator is a person who is complaining of wrong, as you have seen. So we call him the plaintiff, although after the Lord Wolf reforms in the UK, they have switched from plaintiff to claimant, by the same thing, except that the acceptable language in Ghana is the plaintiff and not the claimant. Yeah, so he is the one who will sue another individual, and the person who is sued is called like the defendant, as the case may be. Or maybe for certain other type of civil cases like matrimonial, then the person who is suing is called the petitioner. And then the one who have been called the defendant is called the respondent, as the case may be. Or if you are dealing with the criminal, if you are dealing with the human rights enforcement type of case, then the person who initiates the case is called like the applicant. And then the other party against the case is brought against is called the respondent, as it were. As we have indicated here, the plaintiff has a responsibility to establish the liability of the defendant on preponderance of probabilities, or if you look at the old literature, we say like on the balance of what probabilities, as it were. So these are just for our information so that we are clear in our mind concerning the basic or the elementary distinction between these matters. And that is why, so if you look like the table, we put in a very simple way that criminal law concerns offense against the state, and then the civil law concerns dispute between private individuals mainly. Then in terms of parties, criminal law, the parties are the prosecutor, that is the republic, prosecute an accused person. And then we often maybe like the republic against, let's say, Anani. And then the civil laws we have seen, the plaintiff sues the defendant, maybe Kusi against Osei and things like that. Then in terms like the venue, of course, the venue depends on the type of claim. So in that case, there's not so much a difference between whether it's criminal or civil, because all the courts involved have jurisdiction in most of the matters, as we know. Then standard of proof to it that for criminal cases, the prosecutor must prove his case against the accused person beyond reasonable doubt. Then for civil case, the plaintiff must also establish his case on balance or preponderance of what probabilities. Now, in terms of decision, like what is likely to be the outcome of the criminal case, the decision may be that the accused is convicted, meaning that if he is and acquitted, if he is innocent. But for a civil case, defendant may be found liable or not liable. We don't often say guilty, as we know, so let's pay attention to that. So these things we are talking about in case you are invited to do a very simple distinction like this. You need to be systematic and cover all these grounds and then use illustrations as it were. Of course, you also have to touch on sanctions, or after decision, there will be sanction. If it is a criminal case and you're found guilty, of course, the appropriate punishment, either custodia, in which case you are in prison, or capital, there could be death punishment, penalty, or fine, in which case you are made to pay some money to the state as it were. But we know civil, the sanction, or if you like, the remedies that may be awarded at the end of civil cases, either monetary payment in the form of damages or equitable reliefs, as in injunction, specific performance, precision, and so on. So let's quickly keep these things in mind. I will just pause for 1 minute and take questions and then if you have like maybe questions in relation to these particular areas that we are discussing, then we will talk about them. Yes, we can take some questions. If you want to speak, just put up your hand. Or if you want to, not only question, if you want to add, let me put it that way. If you want to make like it was not just about questions, it's also discussion. So if you want to add to it, you put up your hand and then you are invited to speak, as it were. Let me see, is there a hand up? Okay, there's no hand up. Okay, so let me allow Joshua. Yeah, Joshua, please go ahead.
Yeah, Doc, thank you for the opportunity given me to speak. I'm very grateful for that. You made mention of criminal case. Let's say in Wellington versus DPP.
Okay.
That's the locus classical case in US. Proving beyond reasonable.
In the UK.
US. Wellington
right.
versus
Wellington and DPP. Okay. All right.
Wellington versus DPP.
Okay.
In US.
Okay.
Locus classicus case.
On locus classicus.
Yes, where the man was first was sentenced. Yes. Then he went for appeal and won on the ground of proving beyond reasonable doubt.
Do you mean Wilmington against DPP?
Wilmington versus DPP.
Wilmington.
Wilmington, yes. Wilmington.
Not a US case. It's a UK case.
Well, okay, then sorry for the. But that is the title, right?
Yeah, but it's a UK case. Yeah. They decided.
Okay, UK. Thank you.
Okay.
Thank you very much. Yeah. So in the first appearance, he was sentenced. He went for appeal, and then he won on the ground of proving beyond reasonable doubt.
Yes.
Where he used his gun to kill his wife in the in-laws' house.
Yes.
Claiming that he was just pointing the gun at him to just say, if you don't come back to a matrimonial home, I'll shoot, and by error, then it triggered. Yeah. Now, I cited this case before in class. Fine, the lecturer was happy that I cited it. But in Ghanaian criminal cases, is it applicable as a locus classical case? Or you have to cite a Ghanaian locus classical case during the exam?
All right.
Thank you.
Sure, thank you very much. As I said, first of all, Wilmington and DPP is a decision of the UK House of Lords concerning presumption of innocence mainly. And so if you are talking about it being locus classicus, that is a landmark case for the burden of proof of the prosecution, the presumption of innocence, and so on. If that is what you mean, that is fine. Otherwise, it is cited for purposes of just general, okay, somebody would like me to spell it. Okay, let me put it. Wilmington against DPP. Wilmington against DPP. Yeah, I think that is it. Wool and the men. Yeah, Wilmington against the DPP. Yeah, that's the spelling. Yeah, so I don't really know why you said you had a problem when you cited it. It depends upon what you might have cited it for. But let me say that usually when we have like a Ghanaian authority, right? If you have like a Ghanaian authority on a matter, it is preferable that you cite the Ghanaian authority first before, if you want to add any other authority, you do that. So let us also pay attention to that. So let's assume that you wanted to talk about the presumption of innocence or the prosecution having the burden to prove the, what do you call it? The guilt of the accused person beyond no reasonable doubt. That is fine. But if you go to the 1992 Constitution, we have Article 19, I think. We have Article 19, which talk about presumption of what? So assuming, I'm just citing that as an example, assuming you are talking about presumption of innocence and you ignore Article 19 of the 1992 Constitution, you just go to Wilmington against DPP. Yes, it's not wrong, but it's not the best. Let me put it that way. Okay, so let's keep that in mind. Any other? Okay, there's another question from law can be classified into all the following, except civil and criminal law. I don't know, those of you who are, you can look at the chart. You can look at the chart, and then one of you, Mami Ekwe, has put a question there, that the law can be classified into all the following, except A, civil and criminal law, B, adjectival and procedural law, C, law and equity, D, public and private law, And I noticed that, you've made the thing go off. A lot of you are going for C, law and equity. Yes. You see, there is a principle I taught those who sat the exams last semester. And maybe I'll keep hammering that. I mean, I keep saying last semester, I mean last year. When it comes to the multiple choice, there is something I called the elimination method. So by the elimination method, what it simply means is that where a question has been given you in the multiple choice and you are not 100% sure of even the right answer, you can use what we call intelligent guessing to work out the right answer. And 99% of the time, it will be correct too. And that is what we call like the elimination method. So let's apply the elimination method to the question which Mamia Kuya just posed regarding the classification. So let's look at it. We are going to attempt the elimination method on this. I'm not saying we cannot tell the right answer, but just assuming you had a question like that and you're not 100% sure and you need to work out and still get the correct answer because every mark counts. Okay, so let's look at the option A, civil and criminal law. Can law be classified into civil and criminal law? Yes, you take, it sounds something close to probably what you have learned before. So you take that. B, adjectival and procedural law. That is tricky. And those, because adjectival is the same as procedural law, right? As I told you, procedural law is the same as adjectival law. If you like, they are synonyms. They are not antonyms, or they are not different. It's not like saying substantive law as opposed to procedural law, no. So instead of saying procedural law, you can also say adjectival law. So we have to flag B. We haven't settled on B as being a typical way in which you may classify law. So we haven't finished, but we've flagged it. Let's go on to C. As for A, we are certain that yes, you could do some classification as civil and criminal law. That is fine. Now let's go on to C. The law may be classified as law and equity. Law and equity. Okay, so law and equity is problematic. So law, as in law, refers like the common law. So you classify the law as either the common law or equity. Okay. C, let's see. And then let's take D. Law may be classified as public and private law. So those who chose the C, I'll mark you wrong, because if you are looking at contrasts, if you are looking at distinction, like putting two, if you like, maybe classify. So maybe classify means that you are putting them in, if you like, a compartment, right? So some are put in one compartment as civil. Then you put some in another compartment as criminal. Then you put one in one compartment as procedural. What about adjectival? The same thing. So if B had been substantive and procedural law, then I have no problem with B. But under the circumstances, I would say that and let me put it this way. You know, sometimes the challenge we have with some of the questions that come in the form of the multiple choice are also not without debate. Some of them are highly debatable. Highly debatable in the sense that we can get equally good experts who will say that the answers, the options that they have given are not really 100% accurate, as it were. And that is really the case with law, especially when it comes to law multiple choice question. It's not all the time that you'll be able to get, if you like, accuracy with mathematical precision in terms of the option. On the other hand, what you can work towards is what you call the approximation, like the is most close to, or the most suitable, let's put it that way, the most suitable answer. Let's put, rather than the absolutely correct, then maybe nothing like absolutely correct, since we debate some of them. So for example, if you look at the question Mamiekwe has brought, if you take B and C, I mean for A and D, there's no debate. It's usual classification. Yes, you can classify law as civil and criminal law. That is fine, as we've just been discussing. In the same vein, we could also classify law as public law, and then you can also classify it as a private law. That is fine. But then let's come to B and C. Ordinarily speaking, the classification, we don't often care about whether it's common law as against equity. And in fact, with the passage of the, what do you call, the Judicature Act of 1873 to 1875, there has been a fusion of the common law jurisdiction and then the jurisdiction of equity, meaning that one court exercises both equitable jurisdiction and the common law jurisdiction. And if that is so, then an argument could even be made that it is pedantic, or it is just sophistry to be talking about strict classification as, if you like, the common law and the equity. Because since almost the past 200 years, it comes to like the fusion of these two different fields of the law, as it were. So this brings us to B. As I said, adjective and procedural law, they mean the same thing. So since they mean the same thing, you cannot classify one as adjective and one as procedural. It doesn't make sense. And for that matter, that would be like the most suitable answer. So assuming you are pushed to the wall to pick a correct answer here, the most suitable answer would be B. It will not be. Yeah, so that is one thing that we have to pay attention to. But as you look at it, it can be a bit deceptive, isn't it? If you don't do the analysis well. So from your answers, I can see that some of you have gone for C, others have gone for B. And I will side with those who went for B, in the sense that adjective and procedural law, they mean the same thing. If they mean the same thing, and if you look at the other options, sometimes so, you have to bring, what we call the analogy and also sequencing all to bear when you are solving what do you call answer multiple choice type of question. Sometimes a bit of like logic will also help, in the sense that, okay, look at the options. If you look at all the options, if you look at A, option there, it is category. That is law. Law can be put in under one of two categories: civil law, criminal law. That is fine. Then you take D. Law can be put in one of two categories: public law and private law. That is true. Then you take C, law and equity. Law here represents common law. You can say that this is the common law, and then this is the equity. That is fine. Now let's take a B. At the type of procedural, you see that the in terms of like the pattern, the pattern that you have the options A, C, and D. That pattern is really missing as far as B is concerned. And that is the one reason why we are emboldened in our conclusion that B is the most correct answer. Yeah, so thank you, Mamia Kuya. Any other, before we move on? I'll take one more student, one more question before we move on, or one more contribution. UOA, okay. Somebody call UOA, yes. You can speak now. Yeah, UA, go ahead. You can mute yourself. That is fine. Or you put it. Okay, let me see. EOA, please go ahead. Was it by accident? You don't intend to talk? Is it by accident? Okay.
Hello. Hello, Doc.
Oh, sorry, I'll be talking to myself for some time. I think my line went off. Yeah, so I was saying that the person who wanted to speak, if you, okay, let me, I should unmute all. I can unmute all of you. But when I mute all of you, the rule you have to observe is that not until you want to speak, don't unmute yourself. Otherwise, the noise at the various places into the class. So if you agree to observe that housekeeping rule, I have no problem. I'm going to unmute all of you. Make sure that you discipline yourself so that we don't get that kind of confusion that you've been having. Okay. So now you can mute yourself now. You can mute yourself, the person. Okay, all right.
Okay, Doc. Good evening. It's just a reiteration of a question
I
that
said the rest. Let it be this way. Let the lecturer of the paper and only another person who is talking at the time to have the mic on. So all others should have the mic off. Then when that person has finished, and if probably I'm not talking, then you can also unmute yourself and talk so that you have some kind of order. Yes, please, Evelyn, go ahead.
Okay, good evening, Doc. So it's just a reiteration of a question you had missed. It was in the chat.
Right.
So it says, what law changes the titling of criminal cases from the state to the republic? Is it something that we should take cognizance of? What brings about the difference? Why do we have the states at one time and why do we have the republic at another time?
Oh, right. Thank you very much, Evelyn. That is a very useful question. Yeah, so if you look at Article 88, right? If you look at Article 88 of the 1992 Constitution, and in Article 88 of the 1992 Constitution, particularly clause, and in particular clause 3, I think. No, clause, yeah, let's say clause 3 and 4 read together. So clause 3 says that the Attorney General shall be responsible for the initiation and conduct of all prosecution of criminal offenses. Then clause 4, all offenses prosecuted in the name of the Republic of Ghana shall be at the duty of the Attorney General or any other person authorized by him in accordance with any law. Well, what I would say is that the republic, the style republic against the accused person, I think is what is consistent with the trend established by the 1992 Constitution. Now, if you look at the times when we have like maybe like the state against somebody or trade the state against another person, if you look at it, those were the military days, right? When we had like the junta, if you have like a coup d'etat and then they have dislodged the constitutional arrangements, they will still be doing criminal prosecution. But when they're doing criminal prosecution, they will not say republic, because if you use republic, the presupposition is that we have our own civilian constitution, we have used a democratic system to establish the government and all that. And that is why for the military regime, if you look at the law reports, like usually during the military regime, we have like the state versus something. So that is the style which is used for criminal cases during those times. But when we are in a Republican or constitutional regime like ours, 1992 constitutional regime, then we use the republic. We don't say like the state. So I think in substance, they are the same, but symbolically, they suggest different things, as I have said. If you see like the state versus someone, if you are a student of history of law or legal history, you will appreciate that the state is the style which is used during the military regimes, and the republic is the style which is used during the civilian regimes. I think that is the most important distinction I can actually see, unless someone has another thing else. Okay, so I think, okay. So in that,
Doc,
yes, please.
Yeah, but if you look at Republic versus Adekura, it is during the military. Adekura.
Okay.
It is during the military regime where he was shot in Navrongo.
Okay.
Where he shot somebody in Navrongo.
Yes.
They used the Republic versus Adekura.
Yes. And then we have like the other cases like the state versus Ochre and so on. And then but as I said, the most important reason for using Republic versus, let's say, Kosimenu or Republic versus Ativo for criminal cases now is Article 88, because that's what the Constitution says. Let's put it that way. That's what the Constitution says, that all cases should be, criminal cases are initiated in the name of the Republic. So that is the explanation. But if you wanted to actually extrapolate and rationalize trend, at least since 1960 to date, apart from maybe the isolated cases like the example that our friend Ni Amasa just mentioned, you notice that the greater majority of the cases, you will see the consistency in the trend that I suggested, that usually during the Republican regimes, that is a civilian regime, we use the style Republic versus something more. And then during the military regimes, we use the state versus something. But you could have maybe a little bit of anomalies or even like deviations here and there, but that is just isolated cases. Yeah, I think that is it. I think somebody has something there. Okay, all right. So let's move on. I wanted to touch on sources of law. I mean, last year, I think I just moved straight to talk about just an aspect, and I ignored like the rest. Of course, we didn't start early, and my assumption was also that you must have actually discussed some of these. So there was no point actually in wasting time on it. But suffice to say that for sources of law, I will encourage you to look at the relevant chapter in Professor Kwanse's book, and also relevant chapter in my book, chapter 3. Of course, and any other material that you can lay hands on, the same thing. They all start from Article 11 of the Constitution. And then the Article 11 of the Constitution, as we know very well, contains the blueprints of sources of law in Ghana. So when we say sources of law in Ghana, first and foremost, just a quick reminder, what should come to our mind is that we want to know where we derive the various laws that are applicable within the legal system from. And if anything is laying a claim to be law in Ghana, and it cannot be linked to Article 11 of the 1992 Constitution, then that cannot be a law as far as Ghanaian law is concerned. And that is why Article 11 is very important. And again, if we look at Article 11 too, it gives us a sense of hierarchy. If I say hierarchy, that is orderly arrangement, either in ascending order or descending order. So Article 11 clause 1 will talk about the Constitution, and then the 2 talks about 11 1A, the Constitution, 11 1B. It will talk about the enactments. So the enactment here refers to legislation or act of parliament. And then the 11 1C will talk about orders, rules, regulations, what we call subsidiary legislation. Subsidiary legislation, also known as delegated legislation. And then D will talk about the existing law. And the existing law refers to all the laws that were enforced in Ghana immediately before the coming into force of the 1992 Constitution. And the critical date is the laws which were enforced before 7th January 1993. If you put all those laws together, the framers of the Constitution have adopted their own language. And the language they use is the existing law. So if you look at the existing law from the dictionary, you'll not find it, because it's a term of art. It's been given a stipulative meaning in our Constitution. And as I said, it simply means all the laws which were enforced in Ghana before 7 January 1993, when the 1992 Constitution officially entered into force. And then the Fourth Republic also commenced. So let's suppose that in the multiple choice, certain legislations or certain things have been put there. And then you have been told, all the following are examples of the existing law, except. So what should guide you? I think more importantly is the date. You have to look at the particular options that have to be given. If there is any particular law which appear that it was certainly before 7 January 1993, then that should let you know that automatically it's part of the existing law that we are talking about. And 5, the common law of Ghana. The common law of Ghana, as we know, also made up of like the 3 things: the common law, equity, and then the customary law. So let us take this, and then we say, I remember that if you look at the past question, there was a time that there was a question on the sources of law in Ghana. I don't know if any of you remember that question. Can anybody remind us what? I think that question has come before, but I don't remember exactly which particular year. Some of you might have even written it. Anybody? Ni? Remember? Nobody, you don't remember. It doesn't mean that you've written it and you didn't. No, that is not important. So don't worry. I just want to get the question. Okay, since you're not referred to, maybe later on if I'm able to. Sorry, what is it? Which year was that? Yeah, okay, I think my line went off, but I am back. Okay, I'm sure that in the course of time, you will get it and actually bring it for us to look at it. Yeah, so, but what is important is that the sources of law, if you don't know anything at all, no source of law. Because if you don't know sources of law, then you don't know legal system. Let me tell you, for legal system, if you don't know anything at all, there are, let's say, and then 3 or 4 things. You have to know sources of law. You have to know the core structure. Source of law, core structure, and I think of course, judicial president is part of source of law. So source of law, core structure, and then the I was making the point that in terms of legal system, if we did not know anything at all, we have to know sources. We have to know core structure. And then we have to, yeah, sorry, the internet is just misbehaving, but I think let's manage. Yeah, so we're discussing sources of law, and I said that we have to remember the 5 main sources. First one being the Constitution itself. The second one being what we call legislation or Act of Parliament. The third one being subsidiary legislation or delegated legislation. And the fourth one being what we call the existing law. And by existing law, I've explained that I'm referring to the laws which were enforced in Ghana before the coming into force of the 1992 Constitution. That is before 7th January 1993. Then I also mentioned the 5th one as what we call the common law of Ghana. And the common law of Ghana, as indicated, refers to both the common law we developed after 1066 AD Norman conquest of England and Wales, and also the principles of equity we developed the Chancery Court, as well as customary law. Customary law, that is rules of custom, which by usage and practice are applicable to particular communities in Ghana. So these are the things that we have to know. But because we did not know whether you may be invited to write an essay in the part 2, or it will just be examined in the multiple choice, I will suggest that you should be able to explain each of these 5 on your own properly. So let's take the Constitution and let's look at the points that you need to actually address your mind to. If you have to, let's develop it as a substantive or as a full topic on its own, as it were. So for the Constitution, I will remind you that all the things which you have learned in constitutional law, especially when we start constitutional law, introduction to constitution, like what is constitution, those ideas you have to fall on. If you are, for example, explaining the constitution as the first of law in Ghana, and again, Nanadoma, you want to, and again, you have, all of you, some of you are talk back. Yeah. Then again, you have to, if you are describing the constitution or explaining the constitution as a source of law in Ghana, another important point you have to make is that the supremacy. You have to talk about the supremacy clause. If you look at Article, what do you call the 1 as well as Article 2, the supremacy clause of the constitution, the fact that it is the highest law of the land, and all laws which are not consistent with that are supposed to be declared null and void and so on. And anybody at all can go to the Supreme Court for declaration to that effect. And because of how supreme the Constitution is, where the Supreme Court has made declaration regarding unconstitutionality of something, and the Supreme Court has made consequential orders for the wrong to be righted. If the orders of the Supreme Court are ignored, you know the serious consequences which are attendant upon that. In the case of, say, an ordinary citizen who is not a president or vice president, it is a high crime, and that person can go to prison for a period not exceeding 10 years. And if you are president or vice president, that can be a ground for you to remove from office. So those things are there to reinforce the supremacy, the paramount of the Constitution. So if you're talking about the Constitution as a source of law, and you don't talk about these points, you don't get the full marks which you are supposed to get. So these are some of the things that we have to keep in place. So after that, you come to the legislation or enactment as a source of law. So in talking about legislation or enactment as source of law per Article 11, 1B, as we have talked about, first and foremost, you have to tell us what a legislation is. A legislation is a law which is made by Parliament, and then you have to link it to the legislative power of Ghana. Who has legislative power of Ghana? It's Parliament. So you go to Article 93, as well as the 106, right? You go to Article 93, we're told that the legislative power of Ghana is vested in Parliament. So that is an important point for you to make when we are explaining legislation as a source of law in Ghana. And then you should also link it with Article 106, the mode of exercising legislative power. That is, a legislation will start its life as a bill. A bill is a draft law. And the bill must be accompanied by explanatory memorandum. The bill will have to go through first reading, second reading, third reading, consideration stage, and then it is passed. Then when it is passed, it is assented or signed by the president. And where the president does not want to assent to it, you have to make referral to the Council of State. You have to give the reasons and go back to Parliament and all that. So you have to talk about all these matters when you are explaining the legislation as a source of law. And for that matter, if you saw a question on sources of law and you just wrote, you just listed Article 11, and then you just wrote one sentence on each of them, what you have said is not wrong, but it will not give you marks, which will let you smile because you haven't touched on all the important points. So that is what I want to draw your attention to. Because if you look at usually like the scheme, you know, like those who teach Ghana legal system, if you look at the marking scheme, and that is how properly you're supposed to go about some of these things. So you have to know these essential points. And that is why I am at pains to refer you to each of these essential points. Yeah. Then we come to what you call the, of course, if you mention that you go through those stages again, you also have to add the gazette. It will have to be gazetted. If it's not gazetted, Yeah, I don't know why, but I think the MTN is misbehaving. Yeah, so you also have to add the Gazette bit to it to let it be complete. So let us pay attention to that. So I remember very well that there was a question on this particular sources of law some years ago. And some students might have actually attempted it, but yeah, I think the question that the network is misbehaving. Okay, I'll go. Thank you. I think one of our friends, Olivia Doe, has reminded us of the question which came some years ago. And the question was that we were supposed to do brief notes on sources of law in Ghana. Yes, oh, good. Yes, the question might have stated brief notes, but brief notes does not mean that you should just outline just Article 11 and then you consider justice as having been done. No, you need to touch on the essential points that I'm talking about. And don't forget, nobody will penalize you if you have written the key points which we have been exploring concerning each of these sources. No, nobody will panic and say that, why does the question say brief? And you are telling us, let's say, the legislative power, you are telling us about the mode of exercise and Article 106, the fact that it starts as a bill, it goes through first reading, second reading, third reading, and so on. It is assented by president, it is gazetted. Nobody will punish you for telling us about those matters. No, I don't think so. Yeah, so don't let us be misled by the word brief in order to be extremely brief, as some of you were. And that was why a good number did not do well on rather simple and straightforward question. Yeah, so these are the points which need to be noted as far as discussing enactment or legislation as a law in Ghana is concerned. Then we come to the next one, delegated legislation or subsidiary legislation. Delegated legislation or subsidiary legislation, you have to, first of all, make the point that despite the fact that the Constitution is erected upon the flexible version of separation of powers, in which case the Parliament makes laws and then the executive, they carry them out, execute them, and then the judiciary will interpret and all that. Nevertheless, the framers of the Constitution, as well as Parliament itself, have ceded some lawmaking powers to some other bodies, some other functionaries. And when those bodies or functionaries have made law, exercising the delegated authority granted them by the Constitution or by Parliament, we call that delegated legislation or subsidiary legislation. And these delegated legislation or subsidiary legislation, if you look at Article 11 of the Constitution, Article 11, Clause 1, C, it makes mention of what we call the orders, rules, and regulations made by any person or authority under a power conferred by this Constitution as it were. Yeah, so what that means is that delegated legislation, as far as our Constitution is concerned, can be appreciated from two perspectives. Two perspectives in the sense that we are talking about those who derive their power directly from the Constitution to make laws. Ordinarily, if you look at Article 93, think, 93(2) of the Constitution, which we cited earlier on as, if you look at 93(2), the legislative power is primarily located in Parliament. There's no doubt about that. That is true. But for good reason, the Constitution has also authorized some bodies, some functionaries, to also make laws in addition to the primary legislative function of Parliament. And the laws that they make are also considered as delegated legislation. And of course, Parliament also, by the various legislation that they make, may also empower some other functionaries, other bodies or ministers to also make laws pursuant to powers that Parliament has given to them. And the laws that they'll make are also known as delegated legislation or subsidiary legislation. Yeah, so in terms of authority to make delegated legislation or subsidiary legislation, there are two main sources. One source is a power directly derived from the Constitution. Another source is power conferred by Parliament, by legislation that they will make. So the ones which are derived directly from the Constitution, you call those ones constitutional instrument when they make them. So you take the Electoral Commission. The Electoral Commission has the power to make rules, which will govern elections. And the Electoral Commission will do that by means of a constitutional instrument. Now, if you take the Rules of Court Committee, the Rules of Court Committee also have the power to make rules, which will govern procedure in court. So they will make the adjective law or the procedural law, how the various courts are actually run and managed. So the rules that they make, such as the High Court Civil Procedure Rules of 2004, Constitutional Instrument 47, and so on and so forth. These are all examples of constitutional instrument as it were. So it is still delegated legislation because they are not the primary law-making entity. The primary law-making entity is Parliament. And then quite apart from that, we also have a situation in which Parliament will make an act of Parliament legislation. And in that legislation or act of Parliament, it will give power to some other persons to also make some laws to govern some matters in line with the aim and objective of that particular legislation. So let me give you an example. You take the Companies Act of 2019, Act 992. The law, for example, gives the minister as well as the registrar of companies the power to make certain rules, which will enable companies to be addressed properly. So those laws are examples of delegated legislation. Or you take the Local Government Act. The Local Government Act would also give the Minister for Local Government or Local Governance Affairs and Rural Development the power to make what we call the regulations, what we call the legislative instrument, LI, regulations in the form of LI, legislative instrument, either to set up certain district assemblies or sub-district assemblies or some other matters. And the various assemblies or MMDs, which are set up, are also given the power to actually make rules to govern their respective localities or polity. And those laws are called bylaws. So the various district assembly, municipal assemblies, metropolitan assembly, they also make bylaws. And all these are examples of delegated legislation. So when you have touched on all this, then you have to make the point that in order to check the abuse of the power to make delegated legislation, there is a control mechanism in the Constitution. And the control mechanism is found in Article 11, Clause 7. Article 11, Clause 7 requires that all subsidiary or delegated legislation be in the form of orders, rules, or regulation, or whatever, are supposed to be laid before Parliament supposed to be put before Parliament for 21 sitting days. And then on the day that it is laid before Parliament, it is also supposed to be published in the Gazette. The Gazette is the official state mouthpiece. If information is put in the Gazette, the assumption is that every Ghanaian is aware of it. And that is the foundation of the maxim. Ignorance of the law is no excuse. So when something is published in the Gazette, everyone is assumed to be aware. Of course, this is just a legal fiction because, as a matter of fact, even a number of lawyers have never even read the Gazette before. They've never even gone for it. But that is what the law says. So on the day it's laid before Parliament, it's supposed to also be gazetted. And as I indicated, it's supposed to lie before Parliament for 21 sitting days. If after expiry of 21 sitting days, Parliament has, for example, not voted by 2/3 of all members of Parliament to annul it, then automatically it will come into force. And this is where the question that came up last time, that and then the one gentleman or one lady using Huawei wine time 2019. Well, I would prefer that when you come here, you use your name so that I can connect with you properly. Just as my name. So somebody has put it over there that the question asked to them to draft a brief on the sources of laws of Ghana to be presented to World Bank Law Reform Delegation to Ghana. Good. So this is a very good question. And with respect to delegated legislation, one area which needs reform is the point that I just made. That is Article 11, Clause 7, Paragraph C, especially the requirement that when the particular LI or CI or whatever form of delegated legislation is laid before Parliament for 21 sitting working days, and Parliament does not, for example, get 2/3 to annul it. Annul means that to abrogate or repeal. Then automatically it will come into force. Now, the problem with this particular clause is that Parliament does not have power to even change a comma or a letter. And Parliament has only one option. The option is to completely reject the law. Or if you're not going to reject it, then you have to let it come into force. But it may well be that maybe there may be one or two aspects in which Parliament may want to get some modification made in order to let the work achieve its proper purpose. But if you look at the current formulation of the Constitution, especially Article 11, Clause 7C, which says that once it is laid before Parliament, unless Parliament, before the expiration of 21 days, annuls the order, rule, or regulation by vote of no less than 2/3 of all members of Parliament, automatically it shall come into force. That is problematic. So assuming you have been asked a question as came, and you didn't address on this particular aspect, I don't think you have done justice to the question. Because certainly, if you look at this clause, yes, there is nothing to say that it should be laid before Parliament. But of course, if we go to Parliament, we have what they call the standing committees of Parliament. And we have what they call the Parliamentary Committee on Subsidiary Legislation. So they are responsible for exercising oversight over subsidiary legislation or delegated legislation, which is laid before Parliament. But the difficulty is that they have a very little role in the sense that they cannot make changes. They cannot make modifications. And that is a problem. That is and also look at it. If they want to annul it, it requires 2/3 of Parliament. And that is another problem. He said that of all members of Parliament, he didn't say that 2/3 of those who are present, because Parliament has got a quorum. So if the quorum is there, Then if you talk about two-thirds, we're talking about two-thirds of those who are present. Nevertheless, if we look at Article 11, Clause 7C, it is quite emphatic that you need two-thirds of all members of parliament, and that is another challenge. So let's say you have 275 or so, if I'm not mistaken, members of parliament, and to get two-thirds of all, including those who are sick and those who are have traveled, they are all part of the all. That is another Herculean task. And I think that if you are thinking of a reform, that is an area that you can build some arguments and expose the difficulties inherent in the law. Yeah, I think that is one thing that, and then again, another control mechanism for delegated legislation is that, of course, the courts are there, and you know the doctrine of Travaris, and also the doctrine of unconstitutionality. If you make delegated legislation, certainly it must be in conformity with the Constitution. Otherwise, it will be struck down as being unconstitutional. And quite apart from that, if it is in excess of the powers which have been given to the particular body, let's say that if the powers you are using to make the delegated legislation emanate from an act of parliament, and clearly what you are doing is not really permitted by the particular act of parliament, then that is too bad. That is too bad. So that is another thing that we should keep in mind. And again, we also have to address the existing law as another source of law in Ghana. And as I said, for existing law, all that we need to say as far as the existing law is concerned is that we need to be able to explain that by the existing law, as the Constitution itself has told us. If we look at Article 11, clause 4, the existing law refers to both written and unwritten laws of Ghana, which were in force immediately before the coming into force of the Constitution. And as I indicated, that means that we are referring to the laws in force before 7th January 1993, when the Constitution came into force. Yeah, so that is what we should keep in mind. And having explained, then you have to give examples, right? You have to give example. It's not enough just to say that. Just give example. For example, if you tell like the one easy example, Interstate Section 1985, that is an example of existing law. It was enforced before the coming into force of the 1992 Constitution and all that. So that is fine. And again, you need to also touch on the fact that for existing law to continue to be part of the laws of Ghana, it has to pass the test of constitutional compliance. It has to be compliant with the 1992 Constitution, meaning that it must be in consonance with the letter and the spirit of the 1992 Constitution. And we see the very well-known case of the IGP case, NPP versus the IGP, if you remember that, concerning the Public Order Decree. Public Order Decree 1972 is an example of existing law. And yet, the Supreme Court did not hesitate to strike almost the entire provisions down as being in contravention of the Constitution, especially the requirement that before you back upon demonstration, you need to get a prior police permit. Now that was found to be inconsistent with the freedom of demonstration, procession, and all that, freedom of expression, and assembly guaranteed by the 1992 Constitution. And because it was not constitutionally compliant, the Supreme Court did not hesitate to actually strike it down. So I've just mentioned that as an example to illustrate the point that the litmus test for an existing law to continue to be treated as part of the laws of Ghana is that it must be in agreement with the letter and spirit of the Constitution. And where that is not the case, then it will have to be interpreted or construed with the necessary modifications, adaptation, and qualifications so as to bring it in conformity with the 1992 Constitution. And that is why I mentioned the NPP against the IGP just as an illustration for us. So when you are done with that, you notice that you've covered reasonable grounds, and there's no way that you won't get the marks you're supposed to get. And finally, we come to the common law of Ghana. So when you are talking about the common law of Ghana as a source of law, all that is required of you is that, first of all, you have to let us know that within the meaning of the Constitution, particularly Article 11, when we say the common law of Ghana, we are referring to three things. First and foremost, we are referring to the common law which developed in England after the Norman Conquest of 1066 AD. Like the body of law, which rules would develop there through the judge-made law, the stare decisis and so on. That is what we call it the common law. And then two, we are also referring to the doctrines of equity, which developed in the Chancery Court. The Chancery Court, in order to mitigate the rigors and harshness of the common law. So that is the second component. And then the third component of the common law of Ghana is what we call the customary law. And by customary law, we are referring to rules of law which by custom are applicable to particular communities in Ghana. So you should take of these three components and be able to say a few words about each of them briefly. Yeah, so once you are able to do, and of course, for customary law, when you talk about it, and if you go back to the question which came up, I sent a brief on source of law to the World Bank Reform Group. Maybe another area you may want to touch upon is that if you look at how customary law is defined in Ghana, it is also problematic because if you look at Article 11, clause 1 of the 1992 Constitution, the other problem we have with customary law is that if you look at the customary law, we are told that there are rules of law which by custom are applicable to particular communities in Ghana. So if you say the particular communities in Ghana, by particular communities, are you referring to only the communities which were in Ghana at the time that the Ghana gained independence or the Constitution came into force or whatever? Or what about other immigrants who have stayed here in significant numbers? They have their own customs and the rest. Would that also be recognized as customary law in Ghana and so on? And I think that these are matters that we can show some creativity, in terms of reasoning, and everybody will become convinced of what we are talking about. And more importantly, you need to make the point about the fact that customary law must also agree with the Constitution, because if you talk about customary law, you cannot divorce it from cultural practices. And if you go into other parts of the Constitution, I think if we look at either Article 18 or so, if you look at there's cultural practices. If you look at the Chapter 5, there is a provision that for cultural practices, I think Article 26, that for cultural practices to continue to be upheld, it must not be dehumanizing. It must be in conformity with the the human rights regime of the Constitution. So that is another challenge to customary law, so that if there's a particular customary law and then it is seen to be out of step or not in conformity with the Constitution, that will be struck down, as it were. And finally, how we prove the existence of customary law. Remember the famous rule in Angu versus Ata. The famous rule in Angu versus Ata, in which the point was made by the Privy Council that, well, any allegation regarding existence of customary law as a law is going to be treated as a question of fact, not a question of law. And the evidence will have to be brought unless it has been proven over and over again that it is so notorious that the court need not evidence before the court can take judicial notice of them. So that is what is known as the in Angu versus Ata, and that's another thing you should keep in mind. That when you say the rule in Angu versus Ata, what does it mean? It was just the point which was made that yes, among other things, before law, when it comes up in the course of adjudication, it will be treated as a question of what? Facts, not as a question of law. And that has important implication because questions of fact are resolvable by evidence. Questions of law are resolvable by legal arguments and research. And questions of law, questions of fact are supposed to be established by evidence which the parties will put before the court and not the judge or the lawyers doing their research. But questions of law are resolved by the judge doing his research with the assistance of the lawyers. So if you say that customary law is a question of facts, what that means is that the judge does not have the responsibility to carry out a research to determine what the customary law is. It's rather the duty of those who are alleging that a certain customary law exists, who have the burden to actually bring evidence to convince the court as whether it is really true that this is a rule of customary law or that is not the rule of customary law. And that, of course, that is the situation which happened before the Privy Council in the Angu versus Ata. And they made the point that the only exception is where a particular rule of customary law, for example, has come up in a number of cases before the court and has been proven and proven over and over again that it is so common, so notorious that the court does not need evidence for it to be proved again before the court will take judicial notice of that. But I must say that the rule in Angu versus Ata have been abolished with the coming into force of the Courts Act 1993 at 459, which makes the point that questions of customary law are not questions of fact, they are questions of law, meaning that it is the responsibility of the judge to go to determine questions of customary law on basis of their knowledge and not necessarily taking evidence from the parties. And on this note, I would like you to pay attention to the Courts Act. You know, if you go to the Courts Act, I think section 50, if you go to the Courts Act section 54, I think 54 and 55, I'd like you to look at it and then pay attention to how practically the court goes about trying to determine whether an alleged rule of customary law is true or not. So if you look at that, the procedure is spelled out over there. And remember the case of Bila against Salifo. You can read the case of Bila and Salifo as an illustration regarding how the court actually made use of the equivalent provision of the Courts Act at 459 to determine the existence of customary law. You remember Bila and Salifo? I think there has been an allegation of seduction, and then a man actually trying to get the compensation against another person for having, lie with another person lie with his wife and so on. And there was this customary law argument as whether it was the thief of the community who was supposed to take the compensation, what they call the vagina money, or it was the particular husband whose wife had been defiled. And my interest lies in how the court went about trying to make the determination as whether that particular customary law existed or not. So we want to look at that. So this will bring us to end of the discussion of sources of law. And I would like to pause and take questions if there are any. So I'm giving you 3-4 minutes to take questions, and then I'll be ending my class. And as I said, I will let you know other times that we have other classes in addition to the Sunday one, since a lot of you are relatively free. I think I mentioned the case of Bila versus Salifu. Okay, let me release you. If you want to ask a question, you can just talk. Yeah. Sam.
Yeah.
Yes, please. Go ahead.
Yeah. Can I go ahead?
Yes, sir.
Yeah. You was about Article 11.7c.
Yes.
Where you said needs to be looked at again. You know, in Parliament,
yes,
when an organization, government institution laid the regulation for the 21 days, when it is referred to the Committee of Subsidiary Legislation, and then any member of Parliament, upon reading the regulation that has been laid, and you detect any mistake or any fault in it,
yes,
you alert the committee, or the committee will alert. Then the committee will alert the institution to draw that regulation.
All right.
So that's what goes on. Then also there is this, I would say, customary thing that they do. They have something called pre-laying. The institution that is coming to lay that LI will come ahead and give it to the to Parliament, and the Parliament will give it to the subsidiary legislation. Right. They will go on a retreat, meet, and then do all the corrections, and then give it to the institution. Then the institution will come and lay it. Right. So this is how they have cured it. Right. I think you are right. Right. You are right. If we amend the constitution to take charge of that, to cure that. Thank you.
Right. Thank you very much, Honorable. Thank you. Yeah, Joshua, nobody has asked you to be giving appellations. Please ask your question if you want. Okay, so let's come to Sam. I don't know, Sam has...
Thank you, sir.
Hello, sir.
Yes, please go ahead.
Hello, sir.
Yes, please go ahead. Yes.
And sir, please, in your narration, makes the sources of law. But I want to find out, when it comes to existing law, there are some. So how would a statute under an existing law be classified
You're not
under subsidiary legislation?
No, okay, all right. I didn't get...
For example, let's say how does that
Okay, all right, Mr. Samuel. It's all right. It's all right. Whatever I heard, let me try and explain. I think, your network is bad. So what I understand him to be asking about is that if you take existing law, it's made up of a number of things. It's made up of legislation, made up of subsidiary legislation, and so on and so forth. So are you going to deal with them one by one and so on? No. Existing law is treated as one unit. And as I said, the Constitution itself says that existing law refers to the assemblage or the totality of laws which were enforced in Ghana, both written and unwritten law. It was like unwritten law, including even like the judge-made law, customary law, they are all included. But for the existing law, they are given automatic inclusion into the laws of Ghana on condition that they are not inconsistent with the Constitution. If they are inconsistent with the Constitution, necessary modification will be made in order to let them fall in line. Yeah, so that is the existing law. So the existing law is treated as one. We don't break them into the various components as the legislation aspect, social legislation aspect, and so no, we treat them as one. And then the new regime, that is the post 7 January 1993. That is where we have like the legislation, we have the subsidiary legislation, and so on and so forth. Yeah, so I think that is how I would think is better to do about that type of discussion. Okay, let's take Aniaba. I take the last, I think, 3, and then we will end. Yeah, Aniaba.
Okay, sir. My question is more or less a follow-up question on what was just asked. So since we say that Article 11 more or less gives us the hierarchical categories of the law, and existing law is somewhere beneath a statute by Parliament. So since the existing law includes statute laws, for instance, you made mention of the PNDC Law 111, the Interstate Succession Act. Are we saying that in that case, a statute enacted after 1992
No, all right.
era?
All right, that is a very good question, Mr. Francis John Aniaba. Okay, let me clarify that point. When I say the Article 11, Clause 1, give political arrangement, needs to be qualified. In the hierarchy here, the Constitution itself as the number one law or the number one source, and the enactment, that's the legislation. But of course, I get your point that if you take like the existing law, we also have legislation from the previous Parliament and also the legislation by the military junta. They are on the same pedestal as legislation made by the current Parliament. Yeah, so in that respect, an act of Parliament is an act of Parliament, so long as it has passed the constitutional compliance test, meaning that it's an existing law, right? In other words, it predated the 1992 Constitution. Nevertheless, it is consistent with the Constitution. And since if it's consistent with the Constitution, then since an act of Parliament, it will be granted the status and then the respect which is accorded out of Parliament when it comes to statutory interpretation and things like that. So yeah, so in that respect, I agree with you, Francis.
Yeah, Doc.
Yeah, I think let's.
Doc.
Yes. So we take Joshua, then Julian, and Adini Namole, and then I think that we end the class.
Yeah. Doug, I want to know that ask if you start from Article 1-2, making the Constitution 1992 a supreme law of the land, Republic of Ghana.
Then before you move to 11 as the laws of Ghana, is it also bad? Just to
no, but okay. I think if you go to Article 11, 1A, it mentioned the Constitution first. So I think it's the same thing. But if you look at the 11, 1A, this Constitution, and then B, enactments and so on. Yeah, so it's the same thing, I think. Yeah, so now let's take Julian recap here, and then we come to Nia Masa Namole. Okay.
Yeah, good evening, sir, Doc.
Good evening.
Yeah, Doc, please, I beg you, when you mentioned Bila and Salifu, I think I didn't hear the holdings of the court. I didn't hear the holding of the court. So please, I just want to know whether the man whose wife was taken by another was given the compensation we in Tree we call Ayefre, whether it's the man who received the Ayefre or the whole community that received the Ayefre.
Oh, all right. Julian, I think
yes, sir.
I'm not so much interested in who received the Ayefre or what they call like they call it the punchinga or something like the vagina. That's how they put in the language. But my interest in citing that case lies more in how Justice Taylor, right? How Justice Taylor followed the procedure anticipated in Section 54 and 65 of the Courts Act regarding how you establish existence or non-existence of customary law. Yeah. So that is what my interest in. So I would like you to look at it just for purposes of like the procedure, but not so much. Of course, when you read it, it's there, but I don't want to glorify the those aspects. Okay, and Julian knows what I'm talking about. So okay, so let's take the last one. Ni Amasa Namole.
Yeah, thank you very much, Doc. At Article 11 of the Constitution talks about enactment. Then the same article talks about existing law.
Okay.
Is it referring to the enactment as a prospective enactment, or okay? What is the difference between the enactment and then the existing law?
If you look at Article 11, 1B, it says that enactments made by or under authority of Parliament established by this Constitution. So so with respect to 11.1b, the Constitution is very clear. When it says enactment, it's referring to acts of Parliament or legislation made by the Fourth Republican Parliament. And then existing law includes acts of previous Parliament, as well as military decrees, as well as ordinances from the colonial time, as well as judicial decisions, and then the various delegated legislation made under the previous republics, previous military regimes, and also colonial administration. They all form part of the existing law. And that is why it says that existing law refers to both written and unwritten laws, which were enforced in Ghana immediately before the coming into force of the 1992 Constitution. So if you like, all the laws in Ghana before 7 January are called the existing law. And then from 7 January forward, we are starting a new chapter. And the new chapter, we are going to make laws. Parliament to make laws, enactments, legislation. And then other people will also make delegated or subsidiary legislation and so on. Yeah, so all the laws which were enforced in Ghana before 7 January 1993, they are called the existing law. I don't know, Amole, that. Yeah, so have a very good night, and then we will communicate to you, and we will upload the recording on the YouTube. You can follow it and then play it back if you want.
Yeah, Doctor, you are blessing. God bless you greatly.